Hello students. So now we have covered 5 important topics in the previous video. So today I am going to talk about one of the most important topic, and from this particular topic UPSC has asked question twice in the last 7 years. And the topic is the tussle of power between the Lieutenant Governor of Delhi and the elected government of Delhi. So first of all, we will understand that what is the context of our study, because we all know that the tussle between these two is going on for the last 6 and 7 years, which has been in the news continuously. So the today context is recently a new lieutenant governor has been appointed, and he has called the meeting of jail board officers and have issued the directions to them, and this has been objected by the elected government that this is the infringement of their sphere. So the very first context is that again the problem is with respect to the administration and the interference of lieutenant governor in the sphere of the elected government. But we will see that there are different issues between the lieutenant governor and the elected government. For example, there has been an issue with respect to appointment of chief secretary. There has been an issue with respect to the appointment of public prosecutor during Delhi riots case. There has been an issue of demand of statehood. There has been an issue with respect to passing of budget in the house of the Delhi Legislative Assembly. There has been an issue with respect to NCT Amendment Act. There is one current issue with respect to MCD amendment or amendment in the Municipal Corporation Act. So there has been 6 or 7 different issues between the lieutenant governor and the elected government. So I will say that this is very easy for any aspirant to write the answer on the issues. But if I ask a very basic constitutional question to you, that why there is a dispute going on, or if I say that this dispute will continuously or will be continuous in nature, it cannot be tackled, I will say, then why I am telling so? And from here the UPSC may frame the question that what is the reason for the controversy between the lieutenant governor and the elected government of Delhi. So now that becomes important. So to answer this particular question, we will have to understand that what is the constitutional provision with respect to the relation between the lieutenant governor and the elected government. So I will say that 2 important articles are Article 239 and 239 AA Clause 4. I will talk about each and everything. Then again, there is Section 49 of NCT Act 1991. Then there is Section 4 Clause 1 and 5 Clause 1 of Transaction of Business Rules. Along with this, there is one more provision, that is UT Act 1963. So basically what is happening, that these all rules, constitutional provisions, the law is making a complex situation with respect to the administration. So here now we will see what are these sections are telling. For example, Article 239. So Article 239 simply says that the lieutenant governor is the agent of president. Lieutenant governor is the agent of president. It means that ultimate boss with respect to the administration of union territory is president. Even if you will see Article 239 AB, that is giving power to the president, that is giving power to the president to declare emergency in the Union Territory of Delhi. Then Article 239 AA Clause 4 is talking about the relation between the Lieutenant Governor and the President. And this article says that in case of any disagreement between the Lieutenant Governor and the Council of Ministers and the CM, then the Lieutenant Governor can refer the matter to the President. So how it is becoming a controversy? It is because Lieutenant Governor is sending every matter to the President whenever the central government is asking the President to ask the Lieutenant Governor to send that particular matter. So this is basically the reason for the controversy. Now if you will see section 49 of NCT Act. So basically section 49 of NCT Act says that whatever the directions which is being given by President, presidential directions given from time to time, that must be complied by the Lieutenant Governor and his Council of Ministers. So the word his is creating a problem, because the word should be like this, that Chief Minister and his Council of Ministers. But how the Lieutenant Governor can have his Council of Ministers? So basically this is giving us reflection that ultimate boss as per the section 49 is Lieutenant Governor. That is the problem. Here we are telling President, here we are telling Lieutenant Governor, but we have not mentioned that the elected government is the boss in any of the laws or in any of the rules. Now I am talking about the transaction of the business rules. So transaction of the business rules 4 clause 1 and 5 clause 1 says that, इतना याद नहीं रहेगा but ठीक है, it simply says that the rules for any department will be framed by Lieutenant Governor, and if the Lieutenant Governor is not framing the rule for the transaction of the business of any department, then it will be done by the central government. देखो फिर सेंट्रल गवर्नमेंट का बात आ गया, लेकिन कहीं भी दिल्ली की बात नहीं आई. Now UT Act 1963, it also says that it is must that in case of any bill that is financial in nature, the assent of the administrator or the Lieutenant Governor is must. So again it is giving power to the Lieutenant Governor. Understood? Anyway, we all know that there is another provisions where the Parliament is making the law on the state list and concurrent list, but I am not going into that. It is because obviously it is a union territory and there will obvious provision like this. So I am not going into that. So basically these are the reasons that is creating a complexity in the administration, and that is the reason for the control. Clear? देखो यही से 10 मार्कर के क्वेश्चन आएंगे अगर आया तो. Okay, now we will talk about that what are the different controversies. So the very first thing is public prosecutor. So what has happened that during Delhi riots case, elected government of Delhi has appointed the public prosecutor to put the case before the Delhi High Court, and the name of public prosecutor has been sent to Lieutenant Governor, but Lieutenant Governor has objected and denied to agree with the name of the public prosecutor created by the Delhi government. Next is passing budget. So we have seen that in UT Act, basically what is happening UT Act according to UT Act 1963, that whenever the budget is being passed, it is taking the consent of the Lieutenant Governor, and once the budget is being passed, then it is being sent to the Lieutenant Governor. So it is being sent to the Lieutenant Governor according to transaction of business rules. However, sometimes it has been observed that the Lieutenant Governor is denying to the budget. So basically, nowhere in the transaction of business rules says that the lieutenant governor must agree to that. It simply says that it should be sent to the lieutenant governor. तो देखो सब words का game है. Polity is all about the game of words. If you know how to play this, then it's fine. Otherwise, it's very difficult to frame the statement in the examination. So here what is happening? Nowhere it is written that whether the lieutenant governor should agree to that or not. So it should be made clear. Otherwise, such complexity will occur. Then there is an appointment of chief secretary. Again, you know that along with the appointment of the chief secretary, there is an issue of the slapping of the chief secretary by the MLA of the Delhi Legislative Assembly. So now, appointment of the chief secretary, again, some of the names has been sent by the Delhi government to the lieutenant governor. So lieutenant governor has not agreed to it, and then the chief secretary was appointed as per the name recommended by the Ministry of Home Affairs, because we know that Ministry of Home Affairs is the nodal agency in the terms of the administration of the union territory. Now, another is demand of a statehood. We all know that every time the Mr. Kejriwal is demanding for the statehood. So there is a reason for that, that once it will be accorded a statehood, then the police, public order and the land will come under the Delhi government. So basically, and also in this way, there can be an improvement in the efficiency of the working of MCD. But there are very strong arguments that the statehood should not be given to the Delhi. So one of the strong argument is that it will be a burden on the taxpayer of Delhi. How it will be a burden? Because right now the pension of the government officer, payment of the metro rail officers, higher education, police, everything is borne by the central government. So once you will accord the statehood, then this will be a burden on the Delhi people. Second is security concern. We know about the presidential house, we know about the parliament, we know about the diplomats in the Lutyens Delhi area. So basically, when the police will be under the control of Delhi, then it may cause the security issue, and therefore statehood should not be granted to them. However, there is one argument that we can do what has happened to Washington DC. Basically, Washington DC has the same issue, and Washington DC has been carved out of a state of Virginia. So we can do like this, we can carve the Lutyens Delhi from the rest of Delhi. We can do that. Okay, this is one of the suggestions which you can give. However, there is an issue with that recommendation also. पर कुछ बड़ा बड़ा बात लिखना है तो you can write this. Okay. Then the next is NCT amendment. So NCT amendment, what has happened? So basically, recently the government has brought an amendment in NCT Act 1991. So now according to that, whatever the rules are being framed for conduct of business, of Delhi Legislative Assembly, it should be like the rules of Lok Sabha. First thing. And the second thing that the amendment says that it is must to take the consent of Lieutenant Governor before placing any bill, and all the departmental work should be taken in the name of the Lieutenant Governor. This is the amendment, and this is again empowering the Lieutenant Governor. Then we know about the MCD issue, that there was a trifurcation of MCD, but now the act has been brought and amend the Municipal Corporation Act 1956. According to that, there will be a single MCD now. And whatever the power of the Delhi government earlier to decide that how many councillor seats will be there, it will be taken away, and everything will be done by the special officer to be appointed by the central government. So again, these two reflect the centralization of the power. So these are the different issues which you can write between the Lieutenant Governor and the Delhi government. Now, next thing is what the Supreme Court says on the tussle of power between these two. So there is an important case, and without that, NCT versus Union of India. Without this, you cannot say that, okay, I have written a good answer. So basically, in this particular judgment, Justice Chandrachud was there, and he has said that it is very important to communicate to the Lieutenant Governor. But communication to the Lieutenant Governor does not mean the concurrence of the Lieutenant Governor. Does not mean the concurrence of the Lieutenant Governor. However, the judges have given again a very complex judgment, I will say. On the one hand, they are upholding Article 239 AA4, and they are telling that the Lieutenant Governor should refer the matter to the President, but the reference should be based on the rational criteria or based on the logic. So how you can suppose whenever the power politics is overweight, or when you can say the power politics is outweighing the elected government, then how you can say that this will be based on the rational understanding? However, the court has just said that 239 AA4 is valid constitutionally, but the power to refer any matter to the President does not mean every matter. Does not mean every matter. So Article 239 AA4 says any matter should be sent to the President in case of disagreement, but the judges are telling that any matter does not mean every matter. अब ये तुम मुझे ये बताओ कि they have said highly qualified people, कह दिया. But whenever any matter is now being sent by the Lieutenant Governor, and you will go to the court filing a petition that it is against the judgment of NCT versus Union of India, because the Lieutenant Governor is referring every matter, then the Lieutenant Governor will make a reply in the Delhi High Court that no sir, this was coming under any matter, not every matter. So basically there should be a guidelines that okay, this comes under the meaning of any matter, this comes under the meaning of every matter. So it is not clear. And therefore I will say, or therefore if someone will ask to you that do you think that the tussle between the Lieutenant Governor and the elected government will end? So you should say no. Why no? It is because of the complexity of Section 49 of NCT Act, UT Act 1963, Transaction of Business Rule, and Constitutional Provision 239 and 239 AA4. It is because of before thinking of any resolution of the controversy, you should bring an amendment in these laws and the rules. Then only you can think of that okay, the controversy can end. But in any case, even if you will see TBR, that is the Transaction of Business Rules, you will find that it is talking about the deliberation and the discussion for the cooperation between the Lieutenant Governor and the Delhi elected government. That discussion, deliberation and dialogue is important to resolve the differences. So basically TBR, Transaction of Business Rule, and 69 Constitutional Amendment has brought this NCTD, that is National Capital Territory of Delhi Act. So basically they are providing that yes, there should be a resolution, discussion, but who will discuss? So basically a political will is required and focus should be on collaborative democracy. Collaborative federalism, you can say, federalism. This word has been used by Chandrachud without giving the meaning of collaborative federalism. Collaborative मतलब क्या होता है? कुछ नहीं होता. वो कोलैबोरेशन में कौन काम करेगा फेडरलिज्म में? हर किसी को पावर चाहिए. बट तुम अपने लिए सोच लो कि 10 मार्क्स 15 मार्क्स में आए तो यू शुड यूज दिस वर्ड, दैट इज इन द कंक्लूजन you can use the word collaborative federalism. So in the spirit of collaborative federalism, there should be discussion, debate as per the GNCTD Act and the TBR 1993. That will substantiate your answer. Your answer will be full of knowledge, full of good content, and obviously presentation also matters. So everything I am here to guide you that how to present, how to bring the good content, each and everything with respect to the mains. I am guiding you at IAS 360. Okay. So thanks to all of you. I hope you are enjoying the session. Thank you.